I'm Anoushka Warlow and I am a solicitor at BCL specialising in corporate and financial crime. I act for individuals and companies who face criminal investigations brought by various agencies and may recently have been on the receiving end of a search warrant. The execution of a search warrant, whether on its own or part of a series of raids and arrests, is one of the most invasive and aggressive tools available to a criminal investigator. It often marks the ramping up of a criminal investigation, and it's vital that matters are handled properly and correctly at the raid and thereafter. At BCL, we have considerable experience advising clients during the execution of a search warrant. This often means that we will open a line of communication with the executing officers and will attend the site to make sure that the officers are conducting themselves properly and that they are acting in line with important statutory and procedural safeguards which exist to protect your interests. After a search has concluded, a number of potential issues might arise. Has too much material been seized? Has privileged material or sensitive material outside the bounds of the warrant been seized? Should the warrant have been granted in the first place? Or has the agency or the officers conducting the warrant behaved unlawfully or improperly in any other way? Where those issues arise, the mechanism available to challenge the making or the execution of a warrant is judicial review. That is, civil proceedings brought in the High Court, whereby a judge will determine whether the actions of a public body were lawful. One of the most important pieces of evidence is not the warrant itself or the accounts of what happened on the day, but what happened beforehand. Generally speaking, warrants will have been granted by the court following a private hearing at which the authority applying for the warrant will have sought to demonstrate why certain statutory criteria is met. If it transpires that the court has been in any way misled or the authority has overstated its case during the application, that may be a very good basis on which to challenge the resulting warrant. As such, the authorities and the court should be asked to disclose what happened at the hearing so that advice can be taken on whether it forms a basis for a challenge. One of the big questions when challenging a warrant is, what am I trying to achieve? A successful judicial review may result in the warrant being quashed, the material which was seized being returned, and the criminal investigation itself being effectively over. But that's not necessarily the case, particularly where the challenge rests on an easily rectifiable procedural defect. What's interesting is how this application might play out when the basis for the challenge is the conduct of the investigating authority. It follows that bad behaviour shouldn't be rewarded, and case law has firmly established that criminal investigators won't be allowed to benefit from the fruits of an unlawful search where their behaviour has been very bad indeed. But the question of how bad is too bad is one which remains open and which is ripe for further judicial determination. At present, the bar seems to have been set really very high. That a challenge to the search warrant may not ultimately change the course of the criminal investigation is not to say that the process will have been academic. There are a number of strategic benefits that, in the right context, may arise. For example, it can lead to disclosure at a very early stage in a criminal investigation. It can provide an opportunity to engage with and refute the underlying criminal allegations, and it can send a very important message to the authorities.